In 1866, a son was born in the state of Massachusetts, to a father who was a Frenchman. In 1885, he, the parent, went back to France with his family, including his son, then 19 years of age. 2 years later, the son was notified to perform military duty, and on failing to respond, was arrested and imprisoned. He appealed to the government of the United States through the American ambassador in France. Mr. Bayard, the Secretary of State, at that time, instructed the American embassy to use its good offices to obtain the young man's release from military service, but added, "You will, however, advise him that his remaining in France, after he becomes of age, may be regarded as an election of French nationality, and that his only method of electing and maintaining American nationality is by a prompt return to this country." All these young men were born in the United States, but had the right to elect whether they should be a citizen of a foreign country or a citizen of this country. If they had the right to elect to which government they would pay allegiance, they were not exclusively the subjects of this country. They were not natural-born citizens of this country. Again, a citizen of Prussia immigrated to the United States and had a son born to him. Later he returned to Germany with his family, including the son. On reaching the military age, the son was called upon by the German government to perform military duty. The father invoked the intervention of the American legation at Berlin. In that case it was held that the son, being a minor, acquired, under the laws of Germany, the nationality of his father, but did not thereby lose his right to claim American nationality, and that, upon attaining his majority, the son might, at his own election, return and take the nationality of the place of his birth, or remain in Germany. But that, during his minority, and while domiciled with his father in Germany, he must submit himself to the claim of military duty on the part of the German government. Edward Pierrepont, Attorney General, and U.S. Grant. The only difference, in the case of Mr. Hughes and in the case of the subject above examined, is that Mr. Hughes' father did not take him back to England. But, if he had, the English government would have had a claim upon him, which they might have exercised. And if the English government did have a claim upon him, then the United States did not have exclusive jurisdiction over him, and he did not owe to the United States exclusive allegiance, and he was not a natural-born citizen, within the meaning of the Constitution, because he was not naturally a part of the government under the jurisdiction of which he happened to be born. Particularly is this so in view of the declaration of Mr. Porter, Acting Secretary of State, under date of September 14, 1885, when he says, "By the law of nations, an infant child partakes of his father's nationality and domicile." It is not disputed that Mr. Hughes is not a citizen of the United States, but if he had the right to elect, he must have had something to choose between. He was native-born because he was born in this country, and he is now a native-born citizen because he is now a citizen of this country. But, had he been a natural-born citizen, he would not have had the right to choose between this country and England. He would have had nothing to choose between. He would have owed his sole allegiance to the government of the United States. And there would have been no possible question whether he found himself in the United States or in any other country in the world, that he would be called upon to show allegiance to any government but that of the United States. That it was the intention of the men who framed the Constitution to provide that no person should be president except those who were naturally a part of this government, can hardly be doubted by an examination of documents contemporary with the framing of the Constitution. It was originally proposed in the Constitutional Convention that the presidential qualifications be a citizen of the United States. It was so reported to the Convention by the committee which had it in charge on the 22nd day of August, 1787. It was again referred to a committee, and the qualification clause was changed to read natural-born citizen, and was so reported out of committee on September 4, 1787, and adopted into the Constitution. There is no record of debates upon the subject, but the Federalist contains a contemporary comment on it, written by Alexander Hamilton. It reads, "Nothing was more to be desired than that every practicable obstacle should be opposed to cabal, intrigue, and corruption. These most deadly adversaries of republican government might naturally have been expected to make their approaches from more than one quarter, but chiefly from the desire, in foreign powers, to gain an improper ascendant in our councils. How could they better gratify this, than by raising a creature of their own to the chief magistracy of the Union? Federalist elects VIII. The interpretation of their position, as expressed in the Federalist, is corroborated by Mr. Story in his work on the Constitution, in the following words: "It is indispensable, too, that the President should be a natural-born citizen of the United States. The general propriety of the exclusion of foreigners, in common cases, will scarcely be doubted by any sound statesman. It cuts off all chances for ambitious foreigners who might otherwise be intriguing for the office, and interposes a barrier against those corrupt interferences of foreign governments in executive elections, which have inflicted the most serious evils upon the elective monarchies of Europe." Story on the Constitution, Volume 2, page 353-354. Of course, these articles are not used with the idea of suggesting that Mr. Hughes' affiliations and sympathies and present allegiance are to any government but to that of the United States. Any such idea is disclaimed. They are used, however, to show the reason that underlay the constitutional provision requiring a person to be a natural-born citizen if he would assume the presidency of the United States. If, with full knowledge of the meaning of the phrase natural-born, the framers of the Constitution used those words to express a certain idea and to necessitate a certain qualification, then their meaning is the law of the land. That they did use them is undoubted. That they knew what they were writing hardly seems possible to doubt, in view of the contemporary expressions on the subject and the actual change in the phraseology of the proposed Constitution. The records of the Constitutional Convention of 1787, the Federalist, Story, the eminent commentator on the Constitution, all agree that only a natural-born citizen should ever become President of the United States. The Supreme Court of the United States, several Presidents of the United States, numerous Secretaries of State, and an Attorney General, each vested with authority in connection with the law, have commented upon and interpreted the only existing statute in such words as to disqualify from the presidency a person born under such circumstances as surround Mr. Hughes' birth, on the ground that he is not a natural-born citizen of the United States. Take one more authority. In view of the military draft proposed in 1862, on account of the Civil War, under the head of aliens, it was declared by the government at Washington that the following persons were exempt from draft for military service in the armies of the United States. 1. All foreign-born persons who have not been naturalized. 2. All persons born of foreign parents and who have not become citizens. The very year Mr. Hughes was born, the government to which he now pays allegiance officially recognized that it had not the right to call his father to defend the flag, and that it had not the right to call him to defend the flag. The government he now aspires to preside over classed him under the general head of aliens the year he was born, and drew a line of distinction between him and natural-born citizens, between him and those to whom it owed protection, and from whom it had a right to claim protection. Is Mr. Hughes a natural-born citizen of the United States?